say, platform companies avoid their responsibility to society. And I don't know if we also should address this, but we also know testimonies of platforms working with undocumented people throughout shady intermediaries. So agencies who send them to the platform, and like all undocumented workers are being exploited at the labor market. But more in general, I think with this misqualification by claiming that people are self-employed, avoiding taking care of the people, avoiding taking care of paying ordinary taxes or social benefits, and I should say, indeed, exploitation of workers in the platforms.
Thank you very much, Agnes, for setting the scene of this important part of the labor market today, as of today. So I will turn now to Miguel Cabrita from Portugal. And Miguel, if you could tell us what is the state of play and if you are facing the same situation in Portugal.
So hello to you all. Thank you very much to PES for organizing this event. It's a very topical and very important issue. I'd like to say hello to Commissioner Schmit, to Agnes as well, Member of Parliament, and to all the speakers and participants. I think this is a very important issue for many reasons. Because first of all, I think it's clear for all of us that overall, the issues and challenges that we are facing about platform work are more or less broadly the same. Of course, that different countries have different systems in terms of more general regulation of labor markets, of labor law, social protection systems. But I think that the challenge is more or less the same, because in all of our countries, platform work is one of the most visible aspects of the digital transition that is taking place. And it also embodies a lot of the characteristics that are central and core, not only to digital transition, but also to the new forms of work and the pressures on labor market that are taking place in the last decades. So, of course, the pandemics and the acceleration of the digital transition has made this reality more visible and more relevant in many, and it has grown in, I think, all of the European countries. But overall, gig economy and platform and digital platforms do concentrate and to a certain extent embody themselves some of the most radical characteristics and features of contemporary pressures on labor markets, such as extreme flexibility, individualization of labor relations, highly atypical or fragmented work relationships, of course, remoteness, remote work, spatial distance, dispersion of work in many cases, technological mediation, and in the case of the case of platforms, I think that at all levels, at all stages of labor relations, from the interaction between employees, workers, service providers, and their employers or their platforms, but mediation, interaction, also control at all levels, sometimes at a permanent basis. These are characteristics of digital platforms, and they are all concentrated in this form of work, being structural, I'd say, structural trends in the labor market. And of course, I'd like to stress the importance of algorithms and artificial intelligence in all dimensions of the work relations, which is also a very specific feature of working platforms. So all of these aspects in different ways challenge many of the assumptions of our traditional industrial relations and also public policies and labor market regulation. I'd also like to stress that, of course, platforms are far from being a homogeneous reality. They are very diverse. They are extremely complex in some cases. So it is important to be aware that they are not all the same. They cover different sectors. They tend to attract different types of workers. They have different business models as well. They do not behave, all of them, in in the same way. They do not have the same implications for every worker when we consider them separately. We have platforms that attract workers for very specific moments in time, specific tasks, but we also have platforms that require a full-time dedication, or that work, that their business model works based on the fact that people work very long hours, that are connected and waiting to be called for some service. There are also platforms that cover and attract highly skilled workers, but also the completely unskilled, the low-skilled workers in our economies, and even from groups with difficulties in integration, not only in the labor markets but in society at large. In a correlate way to these different profiles, we have platforms that rely on labor force that is more or less dependent on them, and in other cases, platforms that rely on workers that work in perform work in platforms on a complementary, momentary, localized way. So this huge diversity of both the type of work, the workers, also the skills, spanning from the highly qualified services in areas such as multimedia, software development, technology, and other areas that require high specialization, but also low-skilled workers in the transport of goods, passengers, couriers, and so on and so on. This extreme diversity should not divert us and distract us from what is more essential. That is, this model must be regulated, must be adequately regulated. Of course, the challenges are different. They are not the same for these different segments, but there should be an adequate regulation in place. And this is something that often happens with emerging realities. I think it's not the same. It's not the same in different countries. It's not the same at the European level. So I think that all the steps that are being taken, both at the national level and the European level, are mostly welcome, also for our national work concerning platform. I would say that the regulation we must build should be comprehensive, but at the same time able to focus on these different realities. First of all, we should have a concern with the segments that are most exposed to weaknesses in income, access to rights, access to labor market, access to social protection. This is a very crucial segment we should be looking at, but we also should be looking at the other end of the qualification scale, because we should also take a careful look and ensure that platform work is not yet another way to devalue highly skilled labor. This is very important, I think. It's important and it's useful that opportunities are created, different kinds of opportunities, but we should at the same time be able to prevent the lack of decent work and lack of access to rights among the low skilled, but also prevent that this is not yet another factor of stress on how we value and promote the value of skills and highly skilled workers, mainly young people. Another focus should be, and I think this is the case in many of the countries that are now taking initiatives both on the legal side or on other aspects of the regulation of labor market, is the employment status issue. I think that there should be very clear rules. I think that platforms should not be exempted from the obligations other employers have to provide. So this is not to say that I defend that every worker that provides some kind of work in the platform should be, by definition, per se, a priori, a dependent worker, a worker with an employment contract. But on the other hand, platforms should not be exempted from their obligations. And so if a worker provides work and performs work in the platform under conditions that are recognized and that correspond to the basic features of a contract, so there should be a contract. With the platform, with a company that works for the platform, models are different. They can be discussed. I could speak a little bit about what we are now discussing and preparing in Portugal. But
But
nevertheless,
maybe on the national action,
Yeah.
then it will be part of I would
Yes.
say the second part of the debate. So
Okay.
thank you very much, Miguel, for also setting the scene, showing where are the challenges for all these 28 million workers and their diversity, also their diversity of platform business model, and putting the finger on what is the main issue. It's the employment status. But you have been so describing a situation at the national level. Agnes also touched upon the European level with the European Parliament. And so now I'm turning to Nicolas Schmit, or European Commissioner for Job and Social Affairs. And clearly there is an issue on why also it should be addressed at the European level. So Nicolas, if you can explain us or tell us why you think that it should also be addressed at European level, the question of platform work.
Thank you, Yannick. Thank you also for organizing this conference, this exchange of this meeting on platform work. I remember that a few years ago, it was in 2017, when I was still a minister in Luxembourg and also a coordinator of our family for social affairs, we adopted already a declaration on ensuring decent work and social protection in the digital economy. So we addressed already this question of platforms. Since then, the number of platform workers has increased dramatically, very fast, especially also during the pandemic. And we see that the platform work has become certainly a European phenomenon, because we have in all member states platforms. Some of them are already very Europeanized because they are present in all, or at least in a great number of member states. And it's not just European, it has become a global, it has a global dimension, as we know that in all parts of the world now, platforms are developing. So why now act at the European level? Because first, it has become a European economic and social phenomenon, and we should address it also in a European framework, because we have first to create an economic level playing field. Why should platforms more easily develop in one member state and less in another? So I think we have to try to create that's more with the spirit, in the spirit of the internal market, a level playing field, but especially also we have to have a look at the social conditions and the working conditions of platform workers. Here I join absolutely what Miguel has developed. Platforms are extremely diverse. When we are talking about platforms, we first think about the drivers, those who are providing food or working for this kind of services, but it's much more complex, it's much broader. So platforms are very diverse, and this is also, this makes the whole issue even more complex. But why we have to act at European level and creating a social framework for platforms is important, because if we are not doing it, if we are just leaving the situation as it is now, first, member states will react, and there will be a big diversity in the kind of reaction. This might happen. Second, we have a lot of cases at national courts. We have a lot of rulings, more than 100 rulings taken by national courts, and most of these rulings are focused, as Agnes has previously said, on the classification of platform work. So I think we need now a European framework for the social and working conditions of platform workers. Why? There are two other reasons I would like to mention. If we are not acting, if we are not creating, there is first a risk of unfair competition. Because if platforms are not obliged to a certain number of, to respect a certain number of social rules, tax rules, tax obligations, especially labor rights, well, in comparison to other more classical forms of companies, they get an absolute advantage, competitive advantage. So this is inside different business models, we are giving a very high competitive advantage, and mainly due to a low social standards to platforms. So this is a reason, I think, why we have to also to create a level playing field. And the second one, if we do not act here, well, and we just leave things going, and platforms, this way of handling social rights by platform will inspire a lot of other companies, because if they get the feeling that once you are a platform, or once you can, through a platform, employ people as self-employed, well, meaning that this, meaning that you need not pay social contribution, giving other minimum wage or collective bargaining or other social benefits, or just respecting labor rights also in the field of health and safety, well, then there is a risk that companies say, well, we try to finally take out part of our activities and put it on platforms. And so we are working for certain activities which can function under the form of a platform without having these obligations. And therefore, again, we need here a clear framework for platforms at the European level. And I think also that Europe has set important standards in the digital economy already. We have adopted the famous GDPR regulation protecting personal individual data, and this is now Europe has played a role as standard setter, and these standards are now inspiring a lot of other states or a lot of other regions in this context. And here also, I think it's important now to show that on one hand, certainly we are in favor of this development. A platform should develop. They correspond also to a real demand in the economy in different areas, but they should work, they should function under the same rules as other business models, as other companies, giving also workers the same rights. And for our political family, I think this is an absolutely crucial issue. We have contributed to the social dimension of the Industrial Revolution. We have, with the trade union, set the social protection system, the labor rights, working time, minimum wage. All this is part of how we have regulated the world of work of the Industrial Revolution. Now we are in a new kind of revolution, the digital revolution. We have new forms of work precisely coming up. And it is absolutely important to guarantee that what has been achieved previously will not be just diminished, weakened, and even in some ways suppressed during these big changes in the world of work. And therefore, I think also this is an issue for our family. This is an issue for Europe because it goes deep into our social model, and we cannot just accept that in this European social model, there's a new sector, new kind of new business models just escaping from the from the principles and the rights established in the European social model. Therefore, we work on this, and as you know, we will come up with proposals, and I am very happy that also the Parliament has produced a very important report, but I think we discussed this in a second round. Thank you.
Thank you very much, Nicolas. And clearly, we remember well the work you did as chair of the PS EBSCO ministers, among others, this declaration in 2017, and that's why you are now so efficient also in your work as commissioners, following the good work that you did with our ministerial network. Now, yes, you explain again very clearly the situation and what is at stake about our European social model, and the fact that it could be downgraded, that we could have unfair competitions, that workers' rights could be undermined. So I'm turning, and this is my transition to Ludovic from the European Trade Union Confederation. So also yourself, Ludovic, you have been very active with many workers from different companies. So if you could also give your views and more details on what it means today to work through an app, via an app, and impact on workers' social situation. Thank you, Ludovic.
Thank you, Yannick, and I hope you can hear me well. So thanks, interesting for this really relevant debate at the right moment, a right historical, we hope, moment in Europe today, where we are at a moment of making a choice, of making platform companies respect the rules that we have established for decades with traditional companies, where we have won workers' rights that are applied through collective bargaining agreements that are applied also by regulations. And this is exactly what is at stake here. It's ensuring that the workers that are active in the platform economy can benefit from all these rights that were the result of decades of and centuries of fight from the labor movement and the progressive forces. So it was really interesting and important that the previous interventions also showed the variety of models that we can have in the platform economy. And this leads me to the fact that we see exactly the same in the traditional economy. The working organization that you can see in care work or agriculture or insurance work is really diverse. And we know that as trade unionists, because this is exactly why we are negotiating collective bargaining agreements in every sectors to match the different needs of the sectors to the needs of the workers, but through a collective agreement that ensures that all workers are treated without discrimination. In the platform economy, for the moment, this is clearly not happening because there's no collective agreement, and there is unfair discrimination on who is well rated through an application, and this implies a lot on the working organization and the fact that you could have income at the end of the month. It was also said that the question of the level playing field is quite clear, because it is important, because it was mentioned the 28 million workers already active, but there we have to look at the hundreds of millions of workers that are not in the platform economy for the moment, and that could easily their work be transformed to that if there's not a correct social regulation for that. And we see that those who are promoting the platform economy, for example, in California, where they have, we can say that Uber boat it's low through the Prop 22 ballot last year. Here we see that also here they see the opportunity of spreading this model to other sectors, and this is also clearly identified that it could go from agriculture to zookeeping to nursing, executive assistance, tutoring, restaurant work, design, etc. So it's easily conceivable that a lot of professions could be platformizable, if I can say like that. So we have to take the starting point, and that's what we say as trade unions, that even if all platforms are maybe not all employers, every platform can or is already an employer, because it's exactly the fact that they have the algorithm management tool that makes that at one moment, if there's sufficient clients on one hand and sufficient workers in the other hand, they can match this and organize a service. Maybe some of them organize for the moment really an intermediary, are really intermediaries, but the fact that they have this management tool of the algorithm makes that they will become able at one moment to make the choice to become an employer. This means that there is also a human decision behind, not an artificial intelligence decision, a human decision to shift to take from the worker the question, the autonomy. So they know what is the distinction between self-employment and employment. And at one moment, when there's an algorithm that is created and affecting the working conditions, they also decide which part, if the subordination is removed or not. So there's a human decision behind this. I think it's really important. And this leads me to the really important court cases that we saw just recently in Amsterdam, that clearly show that a Uber driver is an employee. But even more than that, when you look in the court ruling, what is really interesting is that it's also explaining what is the modern form of authority through a platform. And only to quote two sentences from these court cases, it's clear, and it's said by the court, the drivers can only register with Uber through the Uber app. The conditions under which they can start using the Uber app are non-negotiable. They must first fully accept the conditions in order to be able to provide taxi ride by way of an app. Uber unilaterally determines the terms under which the driver works, etc., etc. So the question of how the working organization is done is quite clear. So to conclude, maybe before going to the second part of the discussion, is that recognizing the diversity of these platforms do not impeach us to say that we have to put this level playing fields. Then the diversity will be negotiated through collective agreements. But to put this level playing field, we have to make platform respect the rules. And this means that we have to take the lessons from the judicial war that also trade unions have won. We think that now we have won the judicial war, because on the employment status, it's quite clear that the subordination is recognized, but this does not lead to change in the business model. At every time it's an individual case that is seen, and this does not lead to generalization. When that's nonsense, because when then there's a court that is looking at an individual case, is not looking at if I'm as myself organizing as a self-employed, is looking at how the algorithm is working. So it means that the decision should be a decision to generalize the fact that all the workers are either self-employed, if this is the decision, either all the workers are all dependent and they should have an employment contract. And for this, we need policy making. So this is the historical moment in which we are making policy.
Thank you very much, Ludovic. Thank you. I mean, as you said, now we are talking about 28 million workers. In 2021, it was about 24 million in 2018, so it increased a lot in a few years. But as you said, what is happening in that sector could impact all the sector. So it's very important to make progress in terms of legislation. And I wanted to say that today in a Belgian newspaper, I don't know if you can see it, no, not difficult, but in Le Soir, you had two big pages about this issue. Also about, it's a case of Deliveroo, workers in justice claiming their rights, but also the discussion happening at the European level, so showing that really it's a timely debate that we have now. So after what's at stake, the situation now turning to the solution, what we could do. As Nicolas said, we have a long tradition as European Social Democrats, Socialist family, to fight for workers' rights and to make workers' rights happening and defend workers' rights over the time. So I'm turning to Agnes, because Agnes, you have an important work done for the moment, many discussion. And if you could tell us what is happening with these platform workers that are dressed up as, so to say, independent, and how we can make clear the subordination rule in order to defend their rights and in the labor markets.
Yes, indeed. And I think it's also clear, Yonek, that we are just pushing for, I would say, just ordinary requests from our political family. I think every worker, whether he's working online or offline, deserve decent wages, they deserve a fair working condition, they deserve social security. So I think this is our overarching aim. And like Ludovic has already told, there are court cases which gives us optimism, because indeed you mentioned the Uber case. I know from my hometown also a case against Deliveroo. You see cases in the Netherlands, but everywhere in Europe. And we, the workers, people with the workers' interest at heart, are winning most of these cases. But on the other hand, it feels a little bit like a uphill battle, which we should not win from court case to court case to court case, because, for instance, in the case of Uber, a very clear case, the company immediately responded by saying, okay, I'm going to appeal, I'm not going to change my business model. And we know these are platforms sometimes with very large amounts of money from investors behind them, so they can spend much more than the trade union movement on lawyers' fees. So I think indeed we should make a change in the system, and this is I think the core of the proposal the European Parliament put on the table some months ago, where we say perhaps here the comparison with the duck is appropriate. So if it swims like a duck, it walks like a duck, it makes noise as a duck, perhaps it is a duck. So let's assume that those people who are working for a platform with the algorithm as their boss, the algorithm is organizing their work in terms of workload, in terms of working hours and remuneration. Let's then just change the juridical position, and let's assume that these people are workers with the workers' rights, collective bargaining, social security, protection, etc. And if the platform thinks, in this case, for this group of workers, a classification as a worker is not appropriate, let them go to court. So it's called a reversal of the burden of proof of an employment relation. I think if we are able to fit this in the new upcoming legislation around platform work, we are really helping a group of not the most strong workers on our labor markets. We are not forcing them case by case by case by case to go to court and demand justice against this really huge battery of well-paid lawyers paid by these platforms. I think the majority of the court rulings are already crystal clear. It's clear that platform workers are considered by the different judges in the different member states as employees. So our proposal, and we got a majority for this idea, let's turn the table, let's assume that people are a worker, and at the same time, if a platform can really prove that for this worker or that worker, a real self-employed status is the most appropriate one, let them prove them otherwise. I think this would be the way forward. And this would be also just pushing for what I was saying, decent wages, decent working hours, decent social protection. That should be the core of our fight. Thanks.
Thank you very much, Agnes, for clearly putting also your strategy of changing the logic to change the system so that workers are protected and that the burden would be put on the platform companies then to proceed and to go to court and not on the shoulders of the unions and the workers individually. Now, also, thank you, Agnes, again for this work at the European Parliament, but we have also actions taken at the national level. So I'm turning to Miguel to see what in Portugal you are initiating and what you do to frame platform work.
Well, I'd start by saying that in 2018, so a while ago, we were among the first countries to have specific legislation covering platform workers in a specific sector, the individual transport services sector. And why this sector? Precisely because of things that were said earlier. Because in this sector, there was clearly a case of unfair competition with the taxi sector and others. So it was important to have a framework to regulate this sector. At the time, this law included the clarification of the employment status of workers, and there is a legal presumption in place that these platform workers are employees. Nevertheless, they are employees with operators, with other companies that work in platforms. This is now a questionable option, but at the time it was important to frame for the first time the employment status and to provide to these workers access to employment protection, to social protection, which they had none. So it was important at the time, but the law will be also revised, not only about these aspects, but in other aspects as well. In the meanwhile, we have developed also, just another note, this law also included issues such as working hours, working conditions, and so on. But again, for this specific sector and this specific type of platforms, in a way, this law allowed these workers to be included in the general protection framework of other workers, even though they were platform workers, but they worked as if they worked for these companies that could operate in platforms. However, this discussion is ongoing. We had, in the meanwhile, also an extensive paper on the green paper on the future of work. This green paper clearly identified our priorities. We need more information, more transparency, both statistical information, administrative information, not least for inspection bodies, so that they can act in a more thorough and effective way. We need better legal mechanisms to make the distinction between employed and self-employed, especially if we are to move, as we wish, to a situation where not only for this sector, but for an overall regulation of platforms, there is a clarification of the employment status and the presumption that there is a contract between workers and namely the platforms themselves. And this is a key issue, as I said earlier, so for both for the clarification of employment status and also for the adequate social protection. Also, we have this green paper has called for a close regulation of the use of algorithms and artificial intelligence. This is not a specific issue of the platforms. But in platforms, this is a crucial element of the business model, the work relations, everything. So this is, I think that we cannot adequately regulate work in platforms if we don't regulate transparency, equality, non-discrimination, disclosure, accountability in algorithms and in the artificial intelligence tools. So this is, I think, a very crucial issue. And as Agnes said, issues such as the right to representation, the rights to participate in the collective dimension of labor relations, and so on. As a conclusion of this, as a follow-up of this green paper, we have presented a decent work agenda, which covers many areas, not only platform work, but it includes work in platforms. And in this decent work agenda, which has taken the form of a law that the government has approved and it's now up for public consultation, we defend a presumption, and we propose to establish a presumption on specific criteria that an employment contract exists when certain substantive conditions are met. We already have that in the Portuguese law in general, but now we adapt that to the work in platforms because it's very specific. So workers are covered by the more general assumption, presumption that an employment contract is in place, but they now also will have a presumption, if the law is approved, of course, a presumption that the work in platforms is provided under an employment contract. This will apply to all the platforms, and the specific regime that is now applied to the individual transport services will also be revised in this light. That will be a separate process because we have a specific legal framework for that sector. But the revision is also scheduled to take place soon in terms of our law. So it will take place and it will be included in this debate. There is also in this decent work agenda law that we have recently approved, and it is now up for public consultation, that there will be an obligation that algorithms and artificial intelligence tools are accountable, are transparent, that workers have access to the criteria that are being applied, that inspection bodies also have access to those criteria. So to make sure that the algorithms that are in fact core to this business model and how it operates on a daily basis are not in any way discriminating or sidelining labor rights and basic rights of the workers. Of course, and to conclude, as you know, as you might know, yesterday our national budget negotiations failed, so we will most likely have elections soon in Portugal. But I can assure you that if this is the case, as it appears to be, the decent work agenda will be one of the key elements of our campaign and one key element of our electoral platform. So we'll keep working on this, and we hope to be able to push through this important legislation, not only on platform work, but on other areas such as temporary agency work, undeclared work, collective bargaining, and so on. But let's see what happens. Thank you.
Thank you very much, Miguel, and well, congratulations for the good work that we have been initiating on this matter, but also I guess that on behalf of all the other speakers today, to wish you all the best if whether election should take place. We know the commitment of your government, of yourself, of Antonio Costa, Prime Ministers, and the astonishing results that you have been achieving in only a few years in terms of unemployment, social progress in the country. So we are with you by heart and will support you in this fight for social progress in Portugal. I'm turning to Ludovic because we have now actions taking place in the European Parliament, national level, but also again you as a trade unionist with the ETUC and your national organization. I mean, also now in terms of support to concretely to platform workers, what you are doing and the actions that you have been initiating.
Yeah, Thank you. So yes, trade unions have been active since years to try to organize the workers in platform companies. So this is not for sure an easy task, because you know that these workers do not see their colleagues often. So it's even worse when they are working online. So this is not an easy task. Then, of course, we have the tool of collective bargaining, but the problem is exactly that workers the platforms did not recognize themselves as employers. So it was not a tool that was easy, except in some situation in some countries, to reach collective agreements to ensure decent working conditions for these workers. So this means that we had then to go, and I already mentioned the question of judicial, all the jurisprudence, all the legal cases have helped a lot in this regard to show the problem and the wrongdoings by some platforms. And now we are in a moment where we feel that there are two dimensions. We need a directive at EU level to make platform companies respect the rules, and then when they will have to respect the rules, trade unions will have their responsibilities also to organize collective bargaining with these platforms to ensure that we can discuss these working conditions. So it will not be enough to have regulation. We will also need then to convert the try, if I can say it like that, and negotiate with the platforms to organize how they will. But this means that for the policy making and for the EU directive, we are, as the European Parliament is on the same. We are on the same line with the trade unions, asking for a presumption of employment relationship. We think that the presumption of employment relationship is combined with a reversal of the burden of the proof, would change the game in the platform economy. It would change the game because it would not divide workers between themselves by saying you are an employee, you are not a self-employed. This is not the question. Workers, if they want to be self-employed, we have no problem with this. But the question is the primacy of facts. You cannot just sign a paper to say that you have a contractual arrangement with a platform if you are in fact subordinate. And the presumption of employment relationship as a tool can really help in this regard to ensure that we take the starting point that I was mentioning, that every platform can become an employer, and also every platform has the proof, the evidence. They are the most well places to prove if they are not an employer. When workers have no time, no access to the data, or to how the algorithm work to prove this. So in the situation where we are now, with workers having to go to court, it's quite unequal, and even when they win, there's no decision at the end that generalize the court decision. So the presumption of employment relationship asks really to the platform to prove the situation, and there this shift the situation, because not only it should only not only make that workers don't have to go to court themselves and run after the platforms, but neither should the social security institutions or the labor inspectorate have to run after the platforms, because in that case, if we leave this responsibility to the public institutions, then in that case, we are also running after the platforms, running after a new business model that will emerge more and more. So this means that the presumption with a reversal of the burden of the proof has to be a judicial or an administrative procedure where the platform that would like to trigger a rebut of the presumption of employment relationship, that would like to prove that they do not have employees, in that case come in front of a court or an administrative body to show how their algorithm are affecting the working conditions, how the service is organized, and then if the different criteria that were mentioned also in the case of Portugal by Miguel, if criteria of subordination are met, then we do not let them have self-employed. we think it's the only way to really reverse the situation in which we are now. And this would also protect those who are genuine self-employed for the moment, to become also subordinate at one moment when the platform will see that their business model could be more profitable. I'm thinking about interpreters for the moment that are really self-employed and that are more and more reliant on getting work from platforms. They are not the only ones, but it could come from one day to another that they do not have really the independence that they want to have. This policy tool, we think, is really the one that will protect on one hand the genuine self-employed and those and grant the rights to the workers, the huge majority of workers that should have an employment contract that will then allow them to organize collectively, and while organizing collectively through trade unions, negotiate while being protected also, because for the moment we know also that they are disconnected when they organize strike, that they are affected by bad ratings. So all these elements of discrimination, health and safety issues, working time, and wages and protection could be then discussed through collective bargaining with trade unions. But for this, we need the first step. It's to make platform respect the rules through a EU ambitious directive.
Thank you, Ludovic. So the transition is easy, as you are mentioning a EU directive. So I will turn to Nicolas as commissioner and with the right to initiate EU legislation. If you could tell us what are the next steps politically to better protect workers from platform work.
Yes, thank you. Well, just to say that we have seen now how technology has been used to build a business model through which it was tried finally to escape the responsibilities of a normal employer, and through the fiction, in a way, of self-employment. So if you take the driver, or you take the guy with the bicycle, they are told that they are entrepreneurs and they have nothing which we identify as an entrepreneur. So this is really something, and I think the court cases confirm that it was really a fiction which was created, and therefore we talk, by the way, about bogus self-employed. And therefore our first approach is also to go into the direction which has been indicated now, and also a similar direction as our Portuguese friends and some others, like the Spanish, have adopted or are about to adopt. So I think first the presumption, certainly rebuttable presumption, that platform workers are workers, that they are employees and not self-employed. Certainly, we will give a certain number of criteria in this context to finally strengthen also, and in a way also creating here some legal level playing field for eventual court cases in the future. The second will be the reversal of burden of proof. It's up to the platform to show that indeed these platform workers are really self-employed, and again, then the criteria can be used with this objective. So I think this would bring better protection for platform workers. It would also bring legal security, much better legal security, because it would really establish that in principle platform workers are employees, are workers, and if really they are not, then the platform has to show it and correspond to very strict criteria. Now, this is what has been proposed by the report of the Parliament, and we certainly work on this basis in the context of this future directive. The second element, which is important in this context, is the algorithms. I think I don't remember if it was Ludovic or Miguel who said that, well, without the algorithm, there is no platform. So the platform is an essential element of the algorithm is an essential element of the platform. And here, therefore, we have also to define and to better create the rights in relation to these algorithms, because this goes above the platforms. If and certainly we will have to deal with this in a more general context. Now, it's important to do it here with the platforms because there is no platform without algorithm, but algorithms are already used in many other contexts, especially in human resource management. So this is also something we have really to consider. But here, first, if algorithms, and yesterday I had a discussion with representatives of platform workers, and they confirmed that algorithms are extremely powerful, and they are really controlling entirely the worker, the working time, how the work is performed. They give or refuse to give new jobs to the worker. So this is really the center where of the whole system. It's some kind now of dehumanizing the way how people work because they have no employer apparently. It's an algorithm. They cannot dialogue with the algorithm. The algorithm is on the basis of a very specific programming. They do not know. They do not know, which is the property of the platform. The algorithm is finally controlling the work, which, by the way, confirms the relationship of subordination in which the worker is. So we will deal with this in the sense of transparency, but also in the sense of accountability. And accountability, an algorithm, it cannot be accountable. It can only be a human person who is accountable. So there has to be, in a way, a relationship, the possibility of a relationship, a human relationship, once there are difficulties. So this is an essential element because this is not just for platforms. This will be important also for overall labor relations, which are already in some respect managed by algorithms. So there are some other aspects on data protection which have to be looked at, but here we have, I think, the right tools to use on the basis of the regulation I already mentioned. The third element, which is also the European element, is really to have a better understanding how platforms are organized, not just in one country, but in different countries. And this is the transborder dimension of platforms. Most of the platforms, not all of them, but most of the big platforms, especially those who are always advocating that they are not employers and that they have only self-employed, have a cross-border organization. So we have to better understand, we have to trace also how these platforms are organized. Now, one important question is, and this is something I heard so many times from the platforms, is, well, if you transform the platform workers into employees, into workers, we lose all the flexibility and the whole model cannot function. And by the way, it's also the worker who like this flexibility because they like to work whenever they want and so on. Well, the fact is that there are platforms who have transformed their workers into workers with all the rights. So this shows that this is possible. It's not that giving the rights attached to the statute of worker, that this means that the platform cannot function. We have certain platforms having that have given that. We have cooperatives now in the platform world where workers have exactly the same rights as all other workers. So it is wrong to say, well, the platform business model works only with flexibility, and this means self-employment. This is wrong. They can work differently, but they can work differently by giving more rights, and more rights means, well, that the platform has to pay for it. And this means also a bit the consumer has to pay for it. And I think we cannot have a business model going back to the 19th century style capitalism, where finally the worker is paying the whole price for the system. So I think this is not possible. It has been said the millions of dollars or euros, but many dollars, but also sometimes, which have been which platform have got from the stock exchange, because there was this idea, well, this business model will at one stage produce enormous profits because the social cost is so low. And this is something which is unacceptable. So I think the social conditions are extremely important in this context. My last remark is on collective bargaining. If platform workers are workers anyway, they have a right for collective bargaining, but having the right, theoretical right, and really being able of negotiating collective agreements, these are two stories. So we have to make sure also that these workers have all the rights attached to the statute of workers, also in terms of representation, in terms of the right to join a union, and then the right to get collective bargaining. This leaves the question open for those who might be genuine self-employed. And here we are now also looking at the situation of the genuine self-employed and their rights to have fair negotiation with the platform, because there is an imbalance between somebody who is working in the platform and the powerful platforms. So here we should get something which is close to collective agreements or collective bargaining, and this is something which now is a bit difficult in the context of competition law, but I think this has absolutely to be redressed also. But this applies only then for those who are genuine self-employed, because all the other platform workers, being considered as workers, they should have the collective agreements. So, but algorithms, by the way how algorithms function and the rights in relation to this functioning of algorithms has to apply to workers, but also to self-employed. So it's not that self-employed, they do not have any right in relation to algorithms. They should also have transparency, accountability, rights on their protection, individual protection rights, and so on. So this is something which should be extended also to the genuine self-employed. So this is it. Thank you.
Thank you very much, Nicolas, for giving us the next steps and the strategy of the Commission and your strategy. I'd like to thank all the speakers, because I think that we have really, in this 1 hour debate, summarized the challenges that are in front of us. Clearly, I mean, it's about the EU social model. One, it's about workers. We need to ensure that they have decent wages, that they have access to social protection and pensions. It's clear also that it's about having the same rules for every enterprise and company, and to avoid unfair competition, being it on a tax rule, on social rule. And for that, it's clear that we need legislation to make this rule respected. And then also to change the logic. Right now, we are in a logic where workers have to go to court, defend individually their rights, and then even if they are given and proven rights by the courts, then it does not mean that it's implemented for all workers. So by changing the system, changing the logic, as it has been explained, then all the workers could benefit of these rights, and then trade unions at the enterprise level could apply collective bargaining, and collective bargaining will be protected. But I also want to say one thing in this whole debate, why all this is so important. There is also a matter of social justice, of welfare states, because following the recent commissioned impact assessment, once these companies will give contract to their workers, of course, this will initiate new revenues for the member states. And the estimate, it's about 4 billion euro a year. In the difficult situation that we are now, clearly this will also help member states and strengthen and reinforce our welfare state. And we have seen in the current period of COVID crisis that strong welfare state are so important for people. So it's really a multidimensional fight, a multidimensional issue. And I'm very glad to see that, well, we are very mobilized on the issue. And clearly, as Nicolas said, we have a long-standing record of defending European social model. We will continue to do so. And this is clearly one of our objective in the coming weeks, and I would like to really thank all of you for your input, for your involvement, and that's a fight that we will continue together. So thanks a lot. We'll continue, and certainly we'll meet again in this format to discuss about the follow-up and what is happening then at EU and national level. So thanks to you all, and we'll meet very soon. Thank you.
Okay, bye-bye.
Bye-bye.